My name is Becky Rupert McMahon. I'm the Chief Executive of the Cleveland Metropolitan Bar Association. I just started my 9th year here as the Chief Executive. And early in my tenure, in about, I think it was 2016, we started a series of conversations called Hot Talks, which is what today's conversation is. And the idea was to be able to quickly pull together conversations of critical importance, featuring informed, educated, and different perspectives on whatever the ripped from the headline topic of the day might be. Since our inception in 2016, we've hosted a number of different conversations. We began talking about executive orders coming out of the then brand new President Trump administration, focused on immigration. But we've moved into many, many more topics since then, including topics like critical race theory, like handgun laws, and today's conversation, which is taking us squarely into the conversation of what employers and employees both expect from one another, but also require of one another. By way of quick background, today's conversation is coming about as a result of a text that was first heard around LinkedIn and then sort of took on steam, and I think has now been heard around the world, where a senior associate in a law firm sent a text to, or a senior attorney in a law firm sent a text to an associate. And the associate was someone who had just recently come back from maternity leave and informed her employer that she was leaving the law firm to head to another law firm. And in this text that was ultimately made public on LinkedIn, the text, among other things, from the senior lawyer to the associate said that the associate had been using her maternity leave, quote, to sit on her ass while collecting a salary. And the text went on to threaten the attorney with telling the world who she was and described her as soulless and morally bankrupt. Listen, there's no question. The text is indefensible. The lawyer has since left the law firm where he was working, the law firm Zashin & Rich. The firm came out and issued a couple of different statements, not just informing that the lawyer was no longer employed at the law firm, but also apologizing to the former associate and describing a process that the firm was going to undertake in terms of evaluating its culture and its practices in light of these circumstances, and then some. We at the Cleveland Metropolitan Bar Association received a number of outreaches, texts, email, social media, beyond. I myself was flooded with phone calls and text messages from people asking what in the heck was going on and people providing different interpretations of the circumstances that were revealed by the text and the accompanying social media post. Today's goal is not to really dig into the very specific incidents of what did or didn't happen between the senior lawyer and the associate inside that law firm. It is rather to use the firestorm of conversation that came out of those circumstances and that has raised question, and I think in some respects confusion about what is appropriate, what is legal, and what might be ethical. So our goal here is to really create a conversation where both employees and employers at the end of this hour-long conversation can hopefully take away information that will help create a better work environment for all. So with that, let me introduce our speakers today. We have 3 leading speakers in the field of employment law and ethics. Joining us, and I'll just do this in alphabetical order, Matt Besser. Matt is a founder and principal at the Cleveland law firm Bolick Besser Glesius. Of course, I would butcher your name, Matt. Bolick Besser Glesius, which is an Ohio employment law firm that's devoted to providing justice to employees. Thank you for being here, Matt. We are also joined by Sarah Moore, who is an attorney with the Zashin & Rich law firm. As many of you probably found out last week, Zashin & Rich is a law firm that represents employers in employment, labor, and workers' compensation matters, as well as individuals who are in need of family law assistance. Sarah, we appreciate you coming here to the conversation today. And then our panel is rounded out by the one and only Monica Sansalone, who is a Bar Association favorite. Monica is the managing partner of Gallagher Sharp, which is a litigation and business law firm with offices in Ohio and Michigan. Monica focused her practice on professional liability, where she represents lawyers and judges in grievance proceedings, in addition to defending lawyers against malpractice claims. And Monica is often the person that I think of when I'm looking for clarity in the attorney conduct arena. So with that, I thank all three of my colleagues here today, Matt, Sarah, and Monica, for joining us. So with that, we're going to dive in. Our goal today is to talk about what the law requires in terms of family leaves, maternity leaves and paternity, what employers can provide but are not necessarily legally required, what employees can reasonably expect, and at the end of the conversation, we'll talk specifically about what, if anything, we may see happen to the lawyer who sent the text in this instance. So to get things started, I'm going to open up with a question that let me just put to Sarah. Sarah, as someone who is routinely representing employers in this space, let's focus our conversation on parental leave, whether it's maternity or paternity. What does the law require in terms of what employers must provide to their employees?
Thank you, Becky, and thank you, Matt and Monica, for being here as well. You know, it's interesting. I think many people would find it very surprising that our federal government does not have a per se parental, whether it be maternity or paternity, paid leave component that requires employers to provide paid parental leave, so that if an employer or a company provides that benefit is either an added benefit or it arises because there are some states in our nation that have passed parental leave, paid leave laws that provide a specific amount of time to mothers and to fathers relative to birth and placement of a child. So that's the beginning point, and really to have a robust conversation about maternity, paternity, and all things parental within the workplace. We need to also recognize that as we sit here today, there are two very significant changes in the law that are occurring on this topic. And so in December 29th of 2022, the Consolidated Appropriations Act of 2023 was enacted. And in that piece of legislation, there are two acts that touch upon pregnancy and in the workplace. The first one is the Pregnant Workers and Fairness Act. And this one will become effective on June 27th, 2023. It applies to all employers with 15 or more employees. And to provide context for this, the Pregnancy Discrimination Act of 1978, which amended the Civil Rights Act of 1964, that act prohibited discrimination based on pregnancy, childbirth, and medical conditions arising therefrom. And if you were pregnant, you would have the leave that was afforded to workers who were ill or who were disabled on the same basis. It did not require a reasonable accommodation based on pregnancy alone. So the Pregnant Workers and Fairness Act has finally come to the forefront with providing that employers must, again, 15 or more employees must provide pregnant workers reasonable accommodations, utilizing the same framework that's used with the Americans with Disabilities Act, unless there's an undue hardship, which obviously would be very difficult within this arena to justify unless you're in that small employer exception. And Matt, curious as to your impressions relative to the lack of square paid parental leave, and we can talk about FMLA later, I recognize, but that in combination with this first component of the act.
Sure. Well, I'll skip over FMLA, which I'm sure many folks know provides job protected, unpaid parental leave. The lack of paid leave is what it is. The times that we see it tends to be part of a collective bargaining agreement. Some larger employers do offer it. it's frankly not a legal issue because there's no law requiring it. One thing I would add about the PWFA, the new law, is that it fills a significant gap in the law. It is true that up until recently, employers could not discriminate against pregnant employees, but many pregnant employees needed leave or other accommodations that they simply would not be entitled to unless they could point to a coworker whom the employer gave a similar accommodation. So if you think of an employee who's pregnant, needs a lifting restriction, the employer could say, no, we don't give lifting restrictions. And unless the pregnant employee could find a coworker, a non-pregnant coworker, who got a lifting restriction, she's going to be out of luck. And there are some studies out there that said upwards of 2/3 of pregnancy discrimination accommodation cases failed for lack of a comparator. So the new law fills an enormous gap in the law for a lot of pregnant workers.
And the second component of the Consolidated Appropriations Act that touches on pregnancy in the workplace is the Providing Urgent Maternal Protections for Nursing Mothers Act. And again, for context, back in 2010, our country passed the Federal Break Time for Nursing Mothers Act. And that one applied to employers with 50 or more employees. And it ensured that pregnant employees had, after giving birth, obviously, the right to have breaks in private for expressing milk, and that the spaces that would be utilized could not be a bathroom. One under that law could take those breaks. Those breaks would be unpaid if they were not otherwise a paid break. And you would have 1 year within which you could utilize that protection. Part of the Consolidated Appropriations Act of 2023 in passing what's called the PUMP Act, which I gave the whole acronym for before, that expands things dramatically. So now those protections that occurred for the employers who had 50 or more employees apply to all businesses, all employees. Let me say that again, all businesses, all employees. And there are some very minor exceptions, and that's with respect to air, rail, and motor carriers. Now, that law went into effect on December 29th, 2022. So it's in effect now. It's been in effect. And what does that provide? That 1 year time period is now 2 years. It's break time, it's space, it's hygienic space. This space has to be private and free from intrusion. And so in some workplaces, that'll be a room with a locked door. In other workplaces, that might be curtain and signage. The same unpaid piece applies. Salaried employees, you can't take away from their salary. And then the mechanism to deal with violations is that the employee has to give notice to the employer, to give the employer an opportunity to cure, a 10-day period. And beginning April 28th of 2023, the deficiencies, the violations that are not cured can then be followed up with complaint. And Matt, did you have thoughts with respect to this new law?
Yeah, so when the Affordable Care Act added this protection for breastfeeding employees, it left a giant swath of the workforce unprotected. So the protection originally as passed applied only to what are called non-exempt employees under the Fair Labor Standards Act, which is employees who would otherwise be entitled to overtime pay at time and a half under the statute. And someone questioned whether that was the right legal mechanism to add this protection, but that's what they did. And the problem is that the FLSA does not protect salaried employees, office employees, sales employees, a huge swath of the workforce were not entitled to this protection as breastfeeding employees. The Pump Act closes that gap. And so now it doesn't matter whether you're an exempt employee or non-exempt, salaried, hourly, you have this protection as a nursing employee, as a breastfeeding employee to express breast milk for the first 2 years of the child's life.
So listen, so I appreciate the preview of the new laws that are coming, which I think will be the subject of further conversation for sure as they become enacted and we see sort of the employers following suit and employees taking sort of the benefits of these new protections that are coming. I'd love to sort of shift us back to the circumstances that gave rise to today's conversation, and that was really focused on maternity leave. So what I heard you say at the beginning of your remarks is, notwithstanding these new laws that are coming onto the books, there is no mandate for paid maternity or paternity leave under federal law. Is that correct? Okay. And so under the Family Medical Leave Act, there is a mandate for unpaid medical leave when someone goes out on maternity leave. Can you talk a little bit, is it the same paternity as maternity under the FMLA?
Sure. So absolutely right. You know, there's an indirect way for parents to be able to take leave to care for the child after the childbirth, or to care for and help with transitioning an adopted child into the home. And so the FMLA, which most people are familiar with, is a law, federal law, that applies to employers with 50 or more employees. So that's not everyone. So that's the first piece to keep in mind. For the ones that it applies to, there are certain eligibility requirements. And so I have to be employed with the employer 12 months. I have to reach the threshold, of hours in the 12-month counting period. Once I have those things and I'm eligible, I can get up to 12 weeks of unpaid leave. Now, the employee and the employer have the ability to substitute accrued paid leave. And so oftentimes you'll see that indeed is substituted. Within the first year of the birth replacement of the child is the time period within which the FMLA can be taken, and you can use your accrued leave. You have to pay
So
attention.
that could be sick leave, that could be paid time off, that could be
Absolutely.
vacation time.
Absolutely, absolutely. Now, if you have two spouses that are employed by the same employer, there are certain limitations with respect to that. And it's not, a 24-week period. It's a 12-week period that the parents can split between themselves. Matt?
Yeah, so in addition to the FMLA, because the FMLA does exclude a lot of employees of smaller employers, newer employees, there are two other potential protected leaves for working mothers as opposed to the father. One is the ADA, the Americans with Disabilities Act. If the employee, the mother, has a serious medical condition, that's not the legal definition, but if they have a serious medical condition that is caused by the pregnancy or the childbirth, that might be covered as a disability under the ADA. Also, the new Pregnant Workers Fairness Act could consider leave as a possible accommodation necessitated by pregnancy. And so the question is no longer, do they give such leaves to other employees? The question only is whether that leave would be an undue hardship on the employer, which is a much higher standard for the employer to meet, and importantly, shifts the burden to the employer as opposed to the employee.
Right. So under under the FMLA, under the ADA, and potentially this new law, so I'm curious, is there any clarity about if an employee, and let's be specific here, if a woman is out on maternity leave using either one of these federal laws, is there any articulation about what is expected of the woman while she is on maternity leave? Is she required to remain in contact? Is she required to do work? Is she prohibited from doing work? Is there anything that the federal law says about what is or isn't required of an employee who is out on leave under one of these acts?
There is nothing per se that provides clarity. The closest thing we have is With respect to Ohio State employees, there is a revised code section 126.136, and that code section provides for 6 weeks of paid leave for permanent full-time and permanent part-time employees. Within that, the first 14 days is called a waiting period. In that waiting period, per the statute, the employee can choose to work, does not have to. And if you don't, you can utilize your accrued paid leave during that 2-week period. After that 2-week period is over, the following 4 weeks are all paid by the state. Matt?
Yeah, so there are a few things that employees might expect to happen when they're seeking maternity leave. One is under the FMLA, there are notice requirements. And for a pregnancy that proceeds in the ordinary course, there's no significant complication. The FMLA requires 30 days advance notice before you take your pregnancy leave. If the need for leave is unforeseeable because complications arise, then you have to give notice as soon as practical. Once you're on leave, the statute does not require communication of the employee proactively, but the employer is allowed to request periodic updates about the employee's status and return to work. I guess the other thing I would say is if your doctor has provided your employer with medical restrictions, things you can't do, then you can't be doing those things while you're out on leave. So, if your doctor says bed rest for 6 weeks before the birth of the child due to gestational diabetes, you better not let your employer catch you outside mowing the lawn or shooting hoops because, then they can fire you.
But I appreciate that clarification, but when you mentioned, Matt, the potential requirement for providing periodic updates, periodic updates about the status or the condition is not doing substantive work, is it?
No, you're absolutely correct. The employer may not require you to work while you are on protected FMLA leave.
Okay. All right. So now beyond what FMLA and ADA provide, the circumstances of last week obviously occurred in the context of a private employer, a law firm. And there are plenty of organizations, law firms and otherwise, that provide more than the bare minimum. So I would love to shift our focus to talk a little bit about benefits that we see employers typically providing in the context of maternity leave or paternity leave. And Monica, let me just bring you in here. You're a managing partner at Gallagher Sharp. Can you set the stage for us? Describe for us what your policy is at your law firm.
Sure, and I'll say it started with me 23 years ago. My oldest son is now 23 years old. And we had not at that time had a lot of women go out on maternity leave. And I went to the then managing partner, advised that I was pregnant, and they offered me at the time 12 weeks paid leave. That has been our policy ever since. Whether there are complications later down the line, which in fact I had with my first son, who was in the NICU from being premature, they allowed me to take the time that I needed on his behalf beyond that 12 weeks to do what I needed to do unpaid until I came back. And so in fact, with my first child, I took 6 months off, job guaranteed, and they were unbelievably good to me, I will say 23 years ago before this really became in the forefront. We have kept that policy in place. It has worked very well. And in terms of sort of responsibility and context, there are a couple different things that I think come into play for lawyers, which are a little bit different than potentially other types of employees because we have ethical obligations, right? So normally when we have a lawyer who comes to me to say that she is pregnant, this is my due date, we work together to get, and we're a larger law firm, so this is a little bit easier. We get together what those files are, what her transfer memos are, and we reassign those cases to make sure that they are dealt with because we have ethical obligations to our client to ensure that those matters are handled appropriately. And we obviously have the staff and the lawyers to be able to step in for someone who is on leave, whether it's maternity or paternity leave, to do that. So that is our policy. It is 12 weeks paid. If there are unforeseen circumstances due to health, either of the mother, of the child, in those circumstances, we are certainly very flexible in terms of providing those individuals additional time that they may need for that baby to become healthy, for them to be able to come back to work. And it's worked, it's worked very well. And I think in doing that has garnered loyalty out of a lot of women that have worked here. Certainly for me, I've stayed here for 23 years through 3 kids in being able to do that. And I think it's been quite a pretty successful policy in doing that, in handling our lawyers that way. With the question,
Monica, let me interrupt you. Is I assume your policy, your 12 weeks paid is written? It's a written policy?
correct.
And the process that you go through, that you describe, the practice of evaluating client matters, et cetera, as you prepare for someone going out on leave, is that also written into your policy, or is that unwritten practice?
It's unwritten practice, but we talk about it, when someone comes to me to advise me of that, we sit down, we get a time frame. I talk to whoever the partners may be on that file, assuming it's an associate, and we work through that process, the months leading up to when that leave will convene. So there is a smooth transition, and we are ethically handling those files appropriately for our clients. And that's, sort of the flip side. There is no requirement that work be done, but, I have always found lawyers, even if those transition memos have happened, if I need to pick up the phone and say, hey, you've given this transition memo, but I have a question, what happened in XYZ deposition? I've really never had a lawyer give me a problem to say, this is what's going on with the case, give a little bit insight in what's going on. It's always been a pretty cooperative process that we have. We try not to bother those people that are on maternity leave. But again, that may be very different for a law firm that employs 100 people than it may be for a law firm that employs 3 lawyers, right? We have a little bit more of a luxury in being able to transfer those things. So the balance end of what the law requires, and then what we also are required as lawyers to ethically handle things, that's a balance that I think law firms and lawyers, need to understand, and to try to get those building blocks put into place before a given lawyer goes out on leave and someone else can assume those responsibilities on a file. So there aren't, ethical or malpractice implications for dates being calendar, something falling through the cracks. So it's it's a little bit of both. I can't say that we've really ever had a lot of difficulty with that when we needed it. We've never required brief writing or substantive kind of work, during why someone is out on leave.
Great. All right. So let me ask Sarah and Matt a couple of follow-up questions based on what you just described, Monica. So let's start with the basic. Monica says that at Gallagher Sharp, their policy, assuming there are not other medical circumstances, but they provide a 12-week paid leave for people going out on parental leave. What do you see in terms of the industry law? Let's focus on the legal industry, law firms. Is that typical, 12 weeks paid leave? Is that about what you see across organizations?
I'm happy to go first. I've worked at a number of firms in my career, from a medium boutiques to regional to national to where I am today. And I will say that I've not experienced there being uniformity per se. I've been practicing a little over 27 years, and when I started practicing, there were not a lot of women who were pregnant in our industry, very few. And certainly those who went out, and you didn't necessarily see them come back.
Sarah, I don't mean to cut you off, but we're going to run really short on time. So forgive me employing my old deposition skills. So my question is really about the industry in general. Are you seeing today, is a 12-week paid paternal leave, maternity or paternity leave, family leave, is that about consistent across the industry? Recognizing there may be differences one firm to the next, but in general, is that pretty typical?
I would say yes, and the focus right now is more with helping support the fathers as well in accessing the paternity side of it. The maternity, certainly there's work to do, but the fathers are kind of the next focus, I think, within our industry and supporting them to avail themselves of the leave.
And Matt, what's your take on a 12-week paid leave across law firms?
I'm not the right person to ask.
Okay.
I'm not, because employees don't come to me when everything works out great and they have
For
paid
sure.
leave and they're fine.
Yeah,
Got
Becky, I think at least for medium to larger law firms, it's pretty typical, and it needs to be that way because of the competitive market.
Yeah, fair enough. I do see in the question, somebody is asking if we have if anybody knows of any surveys that are out there that provide sort of information either about what the legal industry does or just the business community in general in terms of what kinds of leaves are offered by employers. Anybody aware of surveys or sort of a resource to go to?
I am not, but I
No.
just know from being as a part of a managing
Sure.
partner and talking to other managing partners in the Cleveland area that it is pretty typical. People feel it's the right thing to do, and it's an investment in the future I felt that it was done for me.
Okay, fair enough. So then, Matt, let me ask you a question also back to what Monica was sharing. So Monica described, my words, an unwritten practice in terms of as an employer working with employees who are preparing to go out on maternity leave to talk about workload, cases, status of things, to make sure that files don't get dropped. For the employees that come to you when things don't go well in the family leave, the maternity leave or paternity leave arena, what are you seeing about same or similar kinds of unwritten policies, expectations, practices, et cetera?
Well, I want to be careful here because, as we all know, when cases settle, they often settle with various restrictions on what you can and can't say.
Yep. So my question wasn't about anyone in specific.
I know, I know.
Yep.
So unwritten policies. The answer is the way law firms treat need for maternity leave is as varied as there are employers. Some are very good, some are very generous, and others say they are and aren't. And that's the nature of human beings. It's the nature of businesses. I will say that we have seen some firms where if you are a young female associate and you get pregnant, you maybe not ought to plan retiring from that law firm as a partner in the future.
Okay. Sarah, what do you see on your end as someone who represents employers about what is expected of employees when they're out on leave? Monica described, again, unwritten sort of practices, direct conversations, but unwritten practices. What do you see in general?
It's interesting. It varies by industry. And so outside of the legal industry or industries where there are not ethical components, often you see that there's the basic FMLA kind of back and forth that happens. And there's not much outside of that except from a personal angle with people within the workplace who reach out to one another. With respect to the legal industry, again, it varies. It just varies from firm to firm.
Okay, so I'm interested in all three of your takes. Let's ask a couple of specific questions that are not about these individual events of last week and that particular employee or former employee, but the kinds of issues that were raised by virtue of the disclosure of the text. So let's assume an associate in a law firm goes out on maternity leave and the employer expects that she will be monitoring emails on a regular basis. Is that a legitimate expectation for an employer to have?
I bet we're going to have a disagreement about that.
I bet we will. That's part of why I asked the question.
I think the answer is no, and that prep work ought to be done before the employee takes leave. But if the employee's got a statutory right to protected leave, then it's not legal to expect that employee to be checking their emails every day or whatever interval.
Yeah, I mean, I actually tend to agree with Matt here. I think that the steps, as we've discussed, need to happen beforehand. So then that burden isn't put on the employee who is on leave. I think management, senior partners have the responsibility to have someone monitor those emails, that a bounce back goes on those emails, on who should be contacted. I'm on leave, I may periodically do it, but that those responsibilities, and in some ways it is good ethical practices, be transferred to a lawyer who is practicing full-time and who is, as opposed to, someone who is caring for an infant who is sleep deprived, who is not sitting on their ass, but is sleep deprived, up all hours. They may not be in the best time frame to handle a matter for a client anyway. So I think it's best practices for both the employer and the employee that stuff gets dealt with in advance and transferred to a lawyer that is able to handle that matter ethically and competently, because the last thing that the employer really wants is a malpractice action on the back end, because you have an employee that's sleep deprived that might be missing deadlines. I mean, those are the responsibilities of management, to get those deadlines, those transfer memos, and all of that kind of stuff put into place beforehand. And again, I certainly recognize that this is different for a 3-person law firm than it is for a 100-person law firm. That you have those resources and it's a little bit more difficult. So I think from a practical standpoint, if you have to check in with that employee, to say, like I said before, hey, what is going on with this case? What's your insight about the plaintiff's deposition? We've got this coming up. Take that phone call and field that phone call, periodically. I don't think that that's an unreasonable expectation, either from a professional, ethical standpoint. I just think you have to balance it and have these communications up front. I don't know what the expectations were with this particular situation,
Sure.
what happened, but that's all I can say is what I think are best practices from an ethical and a management standpoint.
Sure. Thanks, Monica. Okay, so Sarah, I'm interested in your take about both. Is it a reasonable expectation that an employer could expect an employee to be checking emails while on maternity leave? And as you answer that, there's a question in the chat, but isn't working while on FMLA, isn't that against the law?
So it's funny, Matt started with, I bet we're going to have a disagreement. We don't have a disagreement here, right? So if you apply for a leave, absolutely, you should take that leave. You should not be interrupted with that leave, all that jazz, right? The difficulty is that that's not the practical reality that we all face sometimes. And what I mean by that is that I've seen situations where the person who's out on the leave wants to continue interfacing in some way. So I think that where the employee wants to continue to be involved, that is their choice. And that is not something that should come from the firm. The other piece that is important is, that email monitoring and everything. It's always possible, practically speaking, that something comes up or a name comes in, a client name comes in, and no one has a context to that, right? And we're a service-oriented industry. We have ethical obligations. And so there will be moments where, from a practical side, there may need to be a reach out. Any such reach outs should be short in duration, should be straight to the point relative to what the needs are or what the question is. Get in and get out. And, of course, along the way, be very kind and be generous with your words. So that would be my take on it.
So what's an employee's recourse?
Becky, can I?
Oh, sure.
I'm sorry, can I just add to that?
Yeah, of course.
Question about whether the employee can work while on leave.
Yeah.
The answer is there's no restriction on the employee doing it, but if the employer lets the employee work while they are out on supposed FMLA leave, there's a very strong argument that that period of work will not count towards the FMLA leave.
I agree. And certainly, to Matt's point, the employer should be ensuring that that time period is not taken away from the leave allotment that's there. Yep.
Yeah.
I agree.
So we're seeing the chat sort of come in with lots of questions around this content about expectations. So, and I'm curious what your takes are about what an employee's recourse is. If an employee is out on leave and an employee is not choosing to do work, but it is being communicated either directly or indirectly that the employer is expecting the employee to be doing work. And I'll just use whether it's checking emails or doing research or whatever the work is. If there's an expectation, what's an employee to do? How should an employee deal with the expectation that is contrary to what the employee's choice is?
This is a hard practical question because many employees, particularly younger employees, lower level employees who are financially vulnerable, are afraid to speak up for their rights. They are afraid to go to HR. They are afraid to say no to their boss. And so they sort of swallow it. But if someone were inclined to assert their rights, then they ought to do so to HR. They ought to do so politely by email so that there's a record of where they sent it, what they said, and when, so that the employer, if they fire you the next day, can't say, oh, we never got your complaint. And then, of course, the employee can call me, which is clearly the best option.
Clearly, nothing like a direct pitch, Matt. I like it. I like it. Sarah, what are your thoughts? Anything different or in addition to what Matt said, other than call Bullock, Besser, Iglesias?
Sure. I think that, the power dynamic is something that we ought all take a look at within the business world. And there are certainly ways to create safe spaces for those who are at the non-power end to be able to have avenues to address these very things. The smaller the organization, the harder it is to create those avenues. The larger the organization, the easier. That said, it's not an excuse not to create those avenues. They're important.
And I'm curious, so there are a couple comments in the chat about the power imbalance that we see between senior members of law firms, like the senior lawyer that was involved here and an associate. And I'm struck sitting here thinking about, well, what about administrative support staff? They are in presumably an even more difficult position in some instances. Do you see inconsistency in terms of how, say, an administrative assistant is treated compared to an associate who goes out on leave?
So, I think if you have a great firm administrator or an HR director, as Matt described, I mean, a good HR director will advocate for support staff, sometimes against management. And I mean that as a positive. You have an assistant in a situation, and I have an HR person who advocates for their position and does that as she or he should, in that situation. And in a lot of ways, this may come out wrong, but support staff in some ways, I don't want to say it's easier, but support staff doesn't have those ethical obligations, isn't handling those kind of cases or bound to the rules of professional conduct to competently represent. And it's easier for someone maybe to slide in and handle those assignments and make those adjustments. So I rarely ever see when support staff is out on leave, whether it's maternity, paternity, taking care. We've had plenty of times where, an elder parent, the sandwich generation is dealing with an elder parent and they're taking that time off. I don't know that we've ever bothered a support staff, in that role. I think that in some ways that's an easier transition to make because lawyers handle cases and support staff, we all utilize different support staff in different ways. So I think it's a little bit, in a weird way, easier for support staff than it is for lawyers, at least in my personal experience.
Okay. So one of and it looks like the chat is going the same direction our talking outline is. So one of the things that came up in the text last week was this, again, an indefensible text. Let me just keep saying that is my take on it again and again. But one of the things that came up was somehow there was particular outrage that this employee, the former associate, was going to leave the law firms immediately within a couple of days of coming back from maternity leave. And I'm interested in terms of what your take is on this concept about, is there an expectation, either one that is based in law or based in realistic ethics or expectation, that an employee who takes advantage of an employer-sponsored leave must return to work at the end of that leave and or must stay as an employee of that organization for some period of time after returning from leave? Sarah, let's go to you.
Sure. I'll start by saying the text is absolutely indefensible and reprehensible, and we acknowledge that. With respect to the question of, do you have them sign something? There's nothing in the law that I'm aware of that has that requirement except for the Federal Employee Paid Leave Act. I believe in that one, federal employees have an opportunity to get paid leave. It runs concurrently with FMLA. And before the individual takes the leave, you have to in writing agree that when you return, you're going to stay for at least 12 weeks. So setting that aside, there is nothing per se out there from a legal vantage point. And so employers, I would not advise create such a requirement because it's an area of the law that is just too ripe with risks and liabilities. Matt?
Yeah, the employer absolutely cannot do that. Legally, morally, the rules of ethics are a separate question. There is not any requirement that the employee come back. There should not be any expectation that the employee come back. And the way I would frame it is that loyalty is not a one-way street. We are an at-will employment state, as most states are. And if a law firm decided it was in their interest to let an employee go, nobody would bat an eyelash or raise a question. And so why would we expect more loyalty from an associate to a law firm than we would expect from the law firm to the associate? And that's not a comment about this particular situation, but it is a comment about law firm world and our expectations about the way associates ought to be treated and what they owe their firms.
And I think, Becky, I would also point out is that, the laws, there are some national movements on getting rid of non-competes, but the law is the one profession, in fact, ethically, we are not allowed to have non-competes. They're unethical. As an employer, as a law firm, I can't have an associate sign a non-compete. It's unethical. They have the right, to go and do when an associate comes in and gives notice for as difficult it might be. You feel that you've given investment into people, you've trained them. My standard pretty much line is, where are you going? Give them insight on that law firm, on what I might think, and you've got to do what's best for your family. And that's the world we live in. We were talking in our prep call yesterday. I think it's rare for lawyers to stay in the same place like they did. I'm probably the last generation to stay at the same law firm for 25 years. And
you're a dinosaur, Monica. You're a
I am a
dinosaur.
dinosaur. But I think what Matt said with loyalty going both ways is you want to invest in people, you want to treat them well, and they want to treat you well. And then that's how you develop the relationship where people stay and want to stay, with it. I do want to comment, if you don't mind, Becky, there's a comment in here about law students and they're sitting with women law students here and how should they react to what happened. I will tell you, I think that the profession, despite what happened last week or 2 weeks ago, has come an extremely, a long way. Like I said, 23 years ago, my son is now a college graduate. When I went to the managing partner and they're like, and then I asked to go part-time. Well, we've never done this before. The profession has come a long way. This is not what I think is very reflective in my belief of how the profession is in Cleveland. I think we're a lot better than that one text is. And I think young women coming out, as young men should come out and ask people, what is it like to work at a given law firm? What is it like to work at a given, for a given partner, and do that due diligence, not to get yourself into that situation. And unfortunately, if you go into a situation like that, get out of it, and get out of it quickly, and don't put up with it. You don't have to.
So Matt, as the lawyer on the Zoom who represents employees on a regular basis, I'm curious what your take is. You've been practicing what now, 15 years? Is that no? How many years?
18, I think.
18. Oh, right. I'm off by 3. All right. You're just so youthful looking. So 18 years into it, do you think that things are better? Are employers getting better? Do you see fewer people coming to you to express concerns?
No, things are not getting better. Things are just as bad as they always were, at least in the last 18 years. They're clearly better than they were in 1977, 78 when they passed the PDA. But, there was a question about how do we change the perception that women on maternity leave are taking advantage of the system. That's a systemic issue. That's a societal issue about the way working mothers are treated and viewed. And that's not something that, we can individually change other than to call it out when we see it. And for those who are facing it, if they're able to be brave enough to stand up against it.
Yeah. I also think that one of the things I was talking to a group of newer lawyers, they're not law students, but newer women lawyers about this topic last week, is the concept of really taking the time when you are made an offer of employment to really take the time to review the handbook, to see the policies, and to ask for opportunity to speak with others inside the organization about how those policies are put into practice, because we know there is often written policy and then there is the unwritten practice. And sometimes those unwritten practices, as Monica described, I think are laudable and create environments where both employer and employee can work effectively together. But sometimes there are unwritten policies where people will say, oh yeah, we give you X, but if we give you 12 weeks of paid time off, but we really wink and a nod, expect you to be on the clock. So what are your thoughts, any of you, about sort of having those conversations up front at the time that employment offers are being made?
Can I jump in here? Because this is really a pet peeve of mine, a pet issue. Looking at the handbook, obviously you want to talk to people who work there, people who have worked there. But as an employee going in, looking at the handbook can't tell you everything, but it might tell you what you need to know. And when we talk about how we can support working mothers or any employee, but let's just say working mothers, let's look at the company's written policies, right? Does the company require you to put all your disputes in confidential arbitration so that if they do discriminate against you, no one will ever know? Do they artificially shorten your statute of limitations to bring a case so that by the time you decide to do something, it's too late? So there's a big difference between employer in an interview saying, oh, we're so friendly to employees, and then what they actually do in practice, what they require of employees. And so if I were advising someone looking at a firm, I would definitely want to see their handbook and see what do they put in paper.
So listen, we are at 12:54, that we are scheduled to end at 1 o'clock. We might go just a minute or two over, but there is one more topic that I want to be sure that we get to, even though I realize we could talk for days about many of these issues. And that is to go back to, even though I said we don't really want to get into the weeds and the specifics of last week's incidents, it is impossible for me to not ask the question, particularly to Monica, although Matt, you've been a long-term engaged member in our grievance committee, so you two are very well-versed in these kinds of issues. But Monica, let me ask the question of you. The text that was sent last week, what are the ranges of possibilities in terms of what could happen to someone who sends a text message like that? Not only did he describe, maternity leave as sitting on your ass, not only did he sort of use some terrible adjectives about being soulless and morally bankrupt, but he really, as I read the text, there's a threat there. There's a threat implied to really do harm to that employee's credibility on a going forward basis. So again, I don't know all the details of that particular circumstance, but in general, Monica, can you talk to us a little bit about someone who sends a text like that or an email or even says it? Is there potential sanction that that person will face with respect to their practice, their license, et cetera?
Sure. I mean, when you look at a text like that, and if there's anything I tell lawyers when I speak to them often, be very careful about what you put in writing. And a heat of the moment text, as it was described, can undo somebody, pretty quickly, unfortunately. So yes, I think that there can be ethical repercussions for texts such as this, and there have been. If you look at Ohio case law on it, I mean, specifically, I would zero in on Rule 8.4 of the Ohio Rules of Professional Conduct, both subsection G and subsection H. G talks about discrimination. And I think arguably you could put this text in a situation of it being discriminatory towards a woman who is out on maternity leave. She's sitting on her ass, which any of us who've had babies know it's not sitting on your ass. And then 8.4H is what we call the catch-all provision, which is anything that adversely reflects on the lawyer's ability to practice fitness to practice law. And, there's always been some argument about, well, this is free speech, or this may not be free speech. And so how could it be violative of the rules? But, we as lawyers give up certain rights that way to be bound by the rules of professional conduct, candor towards the tribunal in our advertising. So free speech, and my light's going to go off here as I warned you guys.
She did warn us. She was going to have to do a yoga move to turn the lights back on.
So, so I think it's probably, somewhat of a close call. If I was defending or representing this lawyer, I would self-report, I would and give all the context, apologize for it. But I do think under 8.4 G and H, there could be consequences. I don't know that it's anything worse than a public reprimand, but certainly consequences for sending some type of text like this, which could be deemed as threatening, discriminatory, and adversely reflect on a lawyer's fitness to practice law. We don't want lawyers acting this way. They shouldn't act this way. And it should, set an example of what you shouldn't send. There are several cases out there where lawyers have been threatening to their paralegals and such like that, that have resulted, in disciplines. This isn't sexual, but sending inappropriate sexual text. None of that is free speech. It's inappropriate. We are bound by the rules of professional conduct, and lawyers should never send text like that to a client, to opposing counsel, to an associate in your office. It does adversely, in my opinion, reflect on your fitness to practice law. There may be extenuating circumstances that I am certainly unaware of, and that's up to that lawyer and whoever may be defending that lawyer if it comes to that. But yes, I do think there could be ethical implications for sending a text such as this.
So before I go to each of the panelists for their final thoughts, let me just say this. There have been a few questions about what happens next after this conversation. Let me say directly, there's a few things that'll happen next. First and foremost, the Bar Association exists to promote the rule of law, which means that we believe in a fair and equitable playing field for all, both whether you're in the legal system or you are a member of the legal industry. So we're going to continue to foster conversations and dialogues that help better educate and inform. And when there are mistakes like the one that we saw last week, which is again indefensible, we're going to take the opportunity to try to do more and to do better to help people learn from others' mistakes. We have a labor and employment section here at the Bar Association that anybody who's a member of the CMBA is free to join. I assume that group, and we're going to take all of these comments and questions. That group is going to dig into what follow-up could we do? Is there some additional resource that we might think about generating? We have a women in law section whose mission is devoted to helping to advance and promote women as they rise up through the course of their career from cradle to grave in the legal industry. It is a great vehicle to not only share stories and to support one another, but also to help help advocate for change around things like pay equity, leave equity, and more. International Women's Day is coming up on March 8th. We will be taking on some of these conversations. And last but not least, in this short commercial, I'll say, the Bar Association is a leader of conversations. And if you think these are important, then get yourself in a leadership role here at the Bar Association. Whether you seek one of the open positions that we have to become a director in our 32-member boardroom at the association, or maybe you want to see your own career go to new heights, we've got a leadership academy. We've got chairs of each of these sections and committees that work here at the bar. The grievance committee is another one that is often looking for people who are interested in the ethical side of the practice of law. There are lots of ways to get engaged, but you got to step up. So this is your invitation. If you want more, if you want to find out how we continue to improve the profession, then take advantage of the opportunity to get involved in the Bar Association, because we got something for everybody. My last question then to everybody as we close out here is, what are your final takeaways? I think the most important piece of this conversation is, what can employers and or employees do at the end of the day to prevent events like last week from happening? So what's your one or two takeaway that you want to really leave our audience with here as we wrap up? And Sarah, let me start with you. You started off the conversation for us, so let me come to you first here as we close things out.
Thank you, Becky. In terms of kind of next steps or where do we go from here, I think, this provides an opportunity for everyone who's heard about this to take stock in terms of where their firm or their company is at. Have you addressed these issues at all? Do your policies and training, are they such that they're just words on a page? Or how are you putting them into action in your firm? There's a lot of work to do relative to women's rights and maternity leave and paternity leave and all the things that go along with it. The key is to keep the conversation going, to keep moving forward, to celebrate the wins and come around the bad stuff to find what good can come from it. And we here are focused on what good can come from this. And, just on behalf of the staff and employees here at Zashin and Rich, we want to thank the bar for the opportunity to be present on this panel today and to be part of the conversation.
Sarah, thank you for joining the conversation and for leaning into the firestorm and wanting to be a part of the dialogue. Matt, let's go to you. What are some of your key takeaways at the end?
Well, I have many, but I'll keep them very short. I'm glad people are paying attention to this issue. It has been ignored or unspoken in legal circles for a long time, and I hope that this does spark a larger conversation. More than that, I hope that it informs how lawyers advise their clients to handle maternity leave issues. And maybe how they look inwardly at their own policies. I think it also raises the larger question about how associates at law firms are treated and quality of life issues. And we all know that those are ongoing issues and areas for improvement. So, I hope it spurs those conversations as well.
Thank you, Matt. Thank you for being here. And thank you again for quick pinch hitting. Kathy Bullock, your partner, was supposed to be with us. She had a minor mishap thanks to her bulldogs. So thank you, Matt, for stepping in. And Monica, let's round it out with you, my friend. And final takeaways.
I think to the women out there, I think you've got to be an advocate for yourself. And if you're in a bad spot, you got to move and get out of it. Find mentors, find people you can talk to and say, is this right? Is this normal? And if you're in a bad situation, be an advocate. I have a daughter now, she's more of an advocate for herself than I've ever seen. I think this generation of women, she's 19 coming out, will be advocates for themselves better than maybe we were before. But you got to be an advocate and not be shy in doing that. And I think to everybody, you leave the profession better than you found it. It's not 1977, as Matt said. But we gotta continue on that, plane and keep moving things forward. So leave the profession better than you found it, I think is my last words.
Fantastic. Thank you, Monica. And then let me sort of finally say, if anybody out there really wants to continue this conversation and or is having personal sort of experiences that you want to be sure are heard, reach out directly. There was obviously the former employee at Ashland Rich last week, I think showed great courage from my perspective in giving the okay to one of her trusted confidants to share the information. If you don't feel like you have a voice, you can reach me at 216-539-3710. Or you can shoot me an email at rmcmahon@clemetrobar.org. I won't dispense legal license. I am a licensed lawyer still, but I am not a practicing lawyer, but I am delighted to help get you better connected, better informed, and empowered as you go forward in your own career and journey going forward. Men and women. But today's conversation clearly demonstrates, I think, that there is still significant more work to be done in ensuring that women find an even playing field in the legal industry. So thank you again to our conversation today as led by Sarah, Matt, and Monica. It was a great dialogue. Again, we could go on for days. Thanks to the 200 plus who joined us. Feel free to share the link to the conversation, which will be available for a replay in just a few minutes. And if anybody else has ideas for future conversations, please don't hesitate to reach out. And with that, Happy New Year. It's the 150th anniversary here at the CMBA, so we're looking forward to a good year of conversation. Thanks, everybody. Take care.
Thank you.